So, good morning, council.
Good morning.
I was looking for your clients. Are they in the?
Judge, he's here with me. He was having not that good a connection issue, so he's right here. I can show you.
And that's fine. Ms. Fleming, were you expecting your client?
Yes, I'm expecting her to appear via Zoom. Let me text her right now.
Judge, I did go to the keys.
Did you have a good time?
It was enjoyable.
Can't really say you went and didn't have fun.
No, it's kind of a fun place. Did a little deep sea fishing and little flats fishing and stuff like that. And of course, Judge LaFlamme gave me such a hard time a couple of weeks ago that, I told him I might have to put his name on the bathroom wall or that. So.
I talked to her earlier.
Oh, I've got
telling her to wait.
Does she go by the name Joy?
Yes. Sorry, that's her.
It says Joy's iPhone, so I was looking for Elizabeth. Okay, Shannon, you can put us on the record. This is a matter of DeLand versus DeLand. Mr. Trushin for the plaintiff, Ms. Ann Fleming for the defendant, and both of their clients are also present. I understand you wish to enter proofs in support of a judgment of divorce, Mr. Trushin?
We do, Your Honor.
Mr. DeLand, I could ask you to raise your right hand, please. You do swear to tell the truth, the whole truth, and nothing but the truth, so help you God? Okay, I'm going to ask you to keep your voice up so we can hear you. You can put your hand down now. State your full name, please, for the record.
Walter Frederick DeLand.
Go ahead, Mr. Trushin.
Thank you, Your Honor. Mr. DeLand, it came a time that, in fact, you had filed for a complaint for divorce between yourself and Elizabeth Joy DeLand. Is that correct?
That is correct.
In that complaint, sir, were the allegations true and accurate at the time that you filed?
Yes.
And are they true and accurate today?
Yes.
During that time period, sir, married to Joy DeLand, you had two children, one of which is a minor at this time. Is that correct?
That is correct.
And what is that gentleman's name?
Gage DeLand.
And he is 17 years of age?
That is correct.
All right. Now, you live in Jackson County?
Yes.
You resided in Jackson County a minimum of 10 days and the state of Michigan 180 days prior to filing. Is that correct?
Correct.
As far as you know, your wife is not pregnant at this time?
No.
As far as, okay. And during that time period, sir, there's been a judgment of divorce that has been drafted by myself and counsel in regard to this case. Is that correct?
That's correct.
Have you had an occasion to go through that completely in all the provisions?
Yes.
And with that, sir, do you agree with those provisions?
Yes.
I'm going to go through those with you now. It is my understanding that you wish that this Judge LaFlamme, to grant a complete divorce of the bonds of matrimony and dissolve them pursuant to the statute. Is that correct?
Correct.
You wish to have the custody of the one minor child, Gage William DeLand, to be joint legal, joint physical. Is that correct?
Correct.
You understand that, in fact, you have to keep the friend of the court and the court advised of the address of the child at all times.
Correct.
Parenting time is to be any and all times agreeable between yourself and the child and Joy and the child. Is that correct?
Correct.
There's a default provision that's been placed in for parenting times, but that's just if you can't agree or there becomes an issue. Do you understand that?
Yes.
Child support, there is to be none between the two of you. You will not pay child support. Joy will not pay child support. Is that correct?
Correct.
Taxes. It's my understanding the defendant, Joy, shall claim the minor child for tax purposes for the tax year of 2021. Is that your understanding?
Correct.
Have you filed taxes with Joy for the 2020 tax year yet?
Not yet.
Is it your understanding you're going to file joint to maximize that return with Joy in regard to 2020 taxes?
Correct.
All right. Professional health care, is it your understanding that the defendant, Joy DeLand, is employed and she is to have health care on the minor child?
Correct.
Is it your understanding that in fact anything that is unreimbursed by healthcare insurance is to be paid 50-50 by the two of you?
Correct.
Alimony and spousal support, sir, have been indicated that in fact it is not to be given to you or your spouse. It's to be forever barred and non-modifiable in any way. Do you understand that?
Yes.
Statutory insurance indicates that in fact any contract of life or endowment or annuity would indicate it would end at this time between the two of you by the judge signing this judgment of divorce. You understand that?
Yes.
Provisions in dower, judge, are the same and agreeable with you, Mr. Deland?
Yes.
You own a home at 8071 Deland Road in Columbia Township. Is that correct?
Correct.
That home is to be the sole and separate property of your wife once this divorce is entered, upon her appropriately paying you the $40,000 equity by March 28th, 2021. Is that correct?
That's correct.
You'll sign any and all documents to effectuate that?
Correct.
You are also to keep as your separate owned property 6441 South Stony Lake Road and any other property you inherited from your parents in regard to real estate as your sole and separate property, clear from any claim by Joy Deland. Is that your understanding?
Yes.
Now, the division of personal property is set out in the judgment of divorce. You've had an occasion to look at that, who gets what personal property,
Yes.
and you agree with those provisions,
Yes.
including all the property you inherited from your parents would be yours. All the property that Joy inherited from her parents solely would be hers,
That's correct.
free from any claims for each one of you.
Correct.
Attorney fees, each pay your own attorney fees. Any other financial obligations you may have in your own name would be paid by you, and you'd hold your wife harmless. Same way with her, any and all obligations she might have financially, she would pay and hold you harmless. Is that your understanding?
Yes.
Your understanding is that in fact, she is to pay off the second mortgage. Approximately your half of that would be $7,000. Is that somewhere in that ballpark?
Yes.
All right. It's my understanding that she has already done that.
Yes.
And with that, then the remainder, the $40,000 minus the $7,000 would be what you would get for your interest in the marital home. Is that correct?
That's correct.
Name change, that Joy is able to change her name if she wishes. The Jackson County Employees Retirement Pension System, originally, sir, you had it where she was your surviving spouse in regard to that, which reduced that income to you. In fact, the Jackson County Employees Retirement System attorney in that has indicated the language that he needs to have, which is contained in this judgment of divorce, to go back to a straight life option. Is that your understanding?
Yes.
All right. And that's your wish. You discussed that with Joy? And any and all other pensions you may have, or any pension or annuity or 401ks that Joy may have, other than the one we're talking about with Jackson County solely to go back to you, would be your separate property and her separate property. Okay. Mutual release, Mr. Deland, in regard to any other causes of action you may have with her or her against you, would be released. The bankruptcy provision indicates that if you do not pay obligations as driven in this judgment of divorce, that either one of you could seek the court's permission to change that into a alimony award to pay those debts. Is that your understanding?
Yes.
And the same way for her if you didn't in fact pay the debts that you've indicated in this judgment that you'll pay.
Yes.
You can exchange documents with each other to effectuate the terms of this judgment. Is that correct?
Yes.
The disclosure of the parties, you've made a full disclosure in regard to personal property, real property, pensions, everything to do with this judgment. Is that correct?
Yes.
Same way as your understanding that your wife, Joy Deland, has done the same thing.
Correct.
If in fact the court finds out later there was something that was missed or omitted, that in fact either one of you could open this back in front of the judge under the jurisdiction of this court to address those issues. Is that your understanding?
Yes.
As far as you know, Mr. Deland, there's nothing out there that you have not dealt with your wife on in regard to personal property, real property, anything of any nature that you've acquired during the course of the marriage. All right. You understand the court will continue to have jurisdiction of this case for a couple of reasons. Number one, to make sure all the provisions are adhered to. And number two, in regard to the minor child, the care, custody, control of that minor child. You understand that?
Yes.
This terminates the attorney's obligation. You understand once the judge signs his judgment and it's entered with the court, that both the attorneys are released from this court action and case and move forward. Your Honor, I believe that handles there. The last thing I would indicate, Mr. DeLand, with all those provisions, you wish this court to grant you an absolute divorce today.
Yes.
Thank you, Your Honor.
Thank you. Ms. Fleming, do you wish to voir dire your client?
Your Honor, yes, please.
Go ahead.
Thank you. Good morning, Joy.
Good morning.
You have heard Mr. Truchin go through all the provisions of the proposed judgment with your husband. Is that correct?
Yes.
And did you participate in settlement negotiations in reaching all of those provisions?
Yes.
And we negotiated without the benefit of any kind of formal discovery, meaning we just exchanged information. We didn't send any subpoenas or have depositions. Is that correct?
Correct.
As you did not feel that that was necessary.
Correct.
Okay. Now Mr. Truchin went all through the provisions. I'm going to simply ask you, do you understand that the provisions regarding your son, Gage, that those provisions may only be modified in the future upon a showing of a change in circumstances? Do you understand that?
Yes.
And you believe that those provisions are in your son's best interests?
Yes.
And the provisions regarding the property settlement, the personal property, the real estate, whether or not you're receiving spousal support and the retirement benefits, those provisions, once the judge signs that judgment, those provisions are final. You understand that?
Yes.
They cannot be changed. Only
Yep, I
enforced.
Yep,
Okay.
I understand.
You know, I'm gonna ask you specifically. Your husband is retired from the sheriff's department. He has a Jackson County employee's pension. And you are giving up your right to receive 1/2 of the marital portion of that. You understand that?
Yes.
And we've discussed it at length, correct?
Yes, we have.
Okay. And you have the means to support yourself now
Yes.
and in the future.
Yes.
And in fact, you have received assets from both of your parents who are deceased. Is that correct?
I have. Yes.
Okay. And under the circumstances, you believe this decision is in your best interests
Yes.
and in the best interests of your family?
Yes.
Okay. And you're making this decision knowingly and voluntarily?
Yes.
Okay. And just for the record, are you pregnant today?
No, I am not.
Okay. Is it also your desire that the court enter the final judgment of divorce as presented?
Yes.
Do you have any further questions of me or of the court?
No, I do not.
Okay. Thank you, Judge.
Thank you. I am satisfied that there has been a breakdown in this marriage. To the extent that the objects of matrimony have been destroyed, there remains no reasonable likelihood the marriage can be preserved. I've signed the consent judgment as well as the uniform support order, and we'll make sure that copies are forwarded to counsel promptly. Thank you both. Good luck to
Thanks,
both
Judge.
of you, Mr. and Mrs. DeLand.
Thank you.
Thanks.
Thank you.
Joy, I'll be in touch with you.
Okay. Thank you.
Thanks. Thanks, George.
Thank you. Take care.
You too.
This is the matter of Bryant versus Towers. Ms. Brittany Bryant is present. This matter was scheduled for a pretrial, but probably shouldn't have been. When the friend of the court recommends an order in a custody case, that's supposed to be recommended as a final order, not as a temporary order. Every now and then they do it the wrong way. That's what happened here. Do you find all of the provisions of that order that was identified as temporary to be acceptable to you concerning custody, parenting time, and child support?
I believe so.
I think both here did.
No. So what I'm going to do then is simply enter an order directing the clerk to enter this temporary order as a final order. Final in the sense that unless or until you or Mr. Towers have some kind of a dispute about parenting time or support, or need to involve the court in adjusting parenting time, which you certainly have every right to do, because I will retain continuing jurisdiction over the file. But for purposes of finalizing the custody order, there really isn't anything more for you to do.
Okay, so this is it then? This is set in stone? This is what we're doing?
This is it. Yep.
Okay.
All right. Thank you, Ms. Bryant. Have a good
All right.
day. Okay, we are on the record regarding Orr versus Orr. Attorney Lauren Yukimoff here for the plaintiff. The plaintiff is also present. The defendant is not. So we're scheduled for a pre-trial today. I see that Mr. Orr is in default. So we can do this a couple of ways. One is you can simply show up at the scheduled trial date and I can take proofs. Otherwise, you would have to notice it up for entry of a default judgment of divorce. Give him notice the required number of days before that final judgment is entered. I leave that up to you, Ms. Yukimoff, as to how you'd like to proceed.
Yes, Your Honor. I actually circulated a motion to enter default, proposed judgment, UCSO, notice of hearing and proof of service on the opposing party yesterday. So that's probably not in your physical file yet. The clerk did receive it and file it this morning. So there'll be the adequate 14 days notice for the motion to enter the default judgment on the 25th. And we can take proofs then and get this finalized.
Wonderful. We'll see you back here then.
Thank you.
You're welcome. Have a good day.
You too.
Good morning, Your Honor.
Good morning. I thought I clicked on Mr. Fallahy. Here he comes. Gentlemen, did you want to do this on the record or off the record?
Mick, are we going to do proofs today?
Well, that would be the hope, is that we can do the pro-con proofs, Judge. I think we have a trial date in 2 weeks. I received a proposed judgment and some other documents from Mr. Whiting yesterday. I've reviewed them. I just haven't had an opportunity to go over them with my client. So I guess my thought would be to maybe change the trial date to a status conference or a final pretrial, whatever the court would prefer. And if we can get the pro-con proofs entered today, hopefully we can get the judgment entered on that date.
Well, I just let the wrong person in. Mr. Shavers, we're not quite ready for your case. I'm going to put you back in the waiting room. Okay, so Fierro versus Fierro, Mr. Whiting for the plaintiff, Mr. Fallahy for the defendant, and both plaintiff and defendant are also present via Zoom. Mrs. Fierro, would you raise your right hand, please? You do swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
You can put your hand down now. State your full name for the record.
Crystal Jewel Fierro.
Go ahead, Mr. Whiting.
Thank you. Ms. Fierro, were the allegations contained in the complaint for divorce true at the time they were signed?
Yes, sir.
Those allegations remain true today.
Yes, sir.
Are all the children that were born during this marriage listed in the proposed judgment of divorce that was circulated yesterday to the parties?
Yes, sir.
To the best of your knowledge, are you currently pregnant?
No.
Are you reasonably certain that this marriage cannot be preserved under the circumstances?
Yes, sir.
You have reviewed the proposed judgment of divorce.
Yes, sir.
Do you understand the terms of that proposed judgment of divorce?
Yes, sir.
Are you planning on voluntarily approving this proposed judgment of divorce?
Yes, sir.
And one final question, are you fully and completely satisfied with the representation that I have provided you and that of my office?
Yes, sir.
Your Honor, I believe I've established a factual foundation to preserve proofs.
Thank you. I am satisfied based on the proofs that there has been a breakdown in this marriage. To the extent that the objects of matrimony have been destroyed, there remains a reasonable likelihood the marriage can be preserved. And we will change your trial date to a status conference date. As long as we have an approved consent judgment of divorce by that date, there will be no need to appear. Mr. and Mrs. Fierro, I see that you have two fairly young children. Looks like you're going to be co-parenting for a while.
Yes.
I always like to give parents a little pep talk. I'm glad you were able, with the help of your fine representation, to reach an agreement. And I hope moving forward that the two of you can be on the same page with your children. It is so extremely helpful when parents, even though divorced, can support each other concerning matters of discipline. Don't let your children divide and conquer. They will if you let them. If you disagree with something the other parent's doing, don't tell the kids that. Whatever you do, have a private conversation. As much as you can, support one another. Your children will benefit greatly. So I hope you're able to do that. I wish you both well, and I'll look forward to receipt of that consent judgment.
Thank you, Your Honor. And Joe, I emailed the proposed documents to you early this morning. So take a look at your email and then I'll give you a call to discuss, okay?
I've received them and I've reviewed them already, Nick.
Oh, okay. Sounds good. I'll give you a call still to discuss, okay?
Okay, thanks.
All right. Thanks, Joe.
That's why I'm going to give you a call as
Thanks,
well.
Judge.
Thanks, Mick. Thanks, Your
Yeah,
Honor.
thanks, guys.
Have a good day, everyone.
Thank you, Judge.
Thank
You're
you.
welcome. You're welcome. We're a couple minutes early. Good morning, Mr. Shavers. You can hear me? Apparently not. I see why. There we go. Mr. Shavers, can you hear me now?
Yes, I can, sir.
Okay, this is the matter of Welch versus Shavers.
Yes.
Mr. Shavers is present. No one else is present. Matter was scheduled for 10 o'clock.
Yes.
I guess I'm not totally surprised that Ms. Welch isn't present because there's no indication in the file that you actually served her with a copy of your motion to terminate the PPO, and that is your obligation.
I never, excuse me, can I say something? I never,
Of course.
I never knew that I filed a PPO. They just said, when I called the officer, he told me to put in for a hearing to get this terminated or whatever. But when I called the clerk, she told me this is the first step that I have to take. And then if the PPO, then that.
All right, well, here's how it works. I don't know what you were told. I will tell you how it really works. How's that?
All right.
Ms. Welch was granted what we call an ex parte personal protection order. That means based upon the affidavit she filed at the time the petition was filed, or rather the verified petition, I issued, let me make sure it was me. Sometimes other judges do this in my absence. I issued the order, and then you have the right to file a motion to set aside, which you did. You filed it timely. And then what has to happen, though, is I have to have at least proof that she was notified of this hearing, so she has the opportunity to appear and convince me that I should keep a PPO in place. It doesn't look like she was aware of this hearing today. I don't have anything in the file to indicate that she was notified of the hearing. Do you know if she was informed of the hearing?
No, I do not know. Nobody never told me that I had to tell her that, so I don't know.
All right, so here's what I'm going to do. I'm sorry, give me just a second to. As far as you know, she still resides at 917 Orchard Place.
Yes.
All right. So here's what we'll do. I'm going to reschedule this in 2 weeks.
Okay.
We will send her notice of your motion, just so that it doesn't get delayed. And we will give her the opportunity to appear. So I'm going to schedule it for 2 weeks from today at same time, 10 a.m.
Okay.
So you'll need to Zoom back in, but I will make sure she gets notice so that she has an opportunity to appear. I will hear from both of you. It will be her burden at that hearing to convince me that circumstances exist that would justify the PPO remaining in place. So I'll hear from her first, and then I'll hear from you, and then I'll make a decision whether or not there should be a PPO in place.
Okay.
All right, so we'll see you back here in 2 weeks, sir.
All right, I appreciate it.
All right, have a good day.
You too.
There was another matter, Lewis versus Fleming, that was set for a hearing on a motion to enter a PPO. There's no proof of service in the file, and no one is present. It could be they're not present because they were unable to effect notice on the other party. If I don't get something filed within the next couple of weeks, we'll simply dismiss the motion. And I think that does it until 10:30.